Good afternoon, everyone. Welcome back for those of you who have been joining us all along, and welcome for the first time if this is your first time sitting in with us. My name is Kristen Cordero. I'm the Deputy Director of Business Services here at the Department of State under Secretary of State Nellie Gorbea. Today is our penultimate session in our Intellectual Property for Your Small Business Summit. Today's topic is, hey, that was my idea. Copyright protection for creative works, also extending onto things beyond copyright as well. We are, as always, joined by Professor Darden, who's going to be taking us through all of what we need to know on this topic today. Just a few minor housekeeping items. This session, as with the other sessions, is being recorded. Anybody who registered for any one of the 4 sessions is going to get a copy of the recordings and the presentation materials from all 4 sessions. So you will see that coming your way. If you registered early on and you joined us, or at least were registered for the 1 or 2 sessions before this one, you should have received an email with the previous 2 recordings. If you didn't get that for any reason, I'm going to put an email address in the chat. You can get in touch with us and we will make sure we get that over to you. The only other thing I have to mention is on the bottom or the top of your screen, you'll see a button that says CC. If you'd like to use closed captioning for this event, you are welcome to do so. And you can toggle that on and off and set the parameters to your liking. Other than that, the chat is open. Feel free to enter any questions as we go, and I will gladly turn it over to Professor Darden. Take it away.
Hi, thank you, Kristen, and welcome everyone. Today, we're talking about ideas and the scope of intellectual property available to ideas. So let me just get my screen up. My goal today is to just give you some introductory comments and then open the presentation up for questions. So as the first slide indicates, I'm sure you've probably heard the expression, copyright or patent that idea, trademark that patent or patent that trademark. Unfortunately, or fortunately, as we'll see in a moment, ideas are not protectable expressions. But they're not, I'm sorry, getting lost here. Ideas are not protectable with any form of intellectual property protection in the United States. Copyrights and patents both cover specific forms of creation or innovation, and we'll talk about that in just a moment. Patents protect specific embodiments of inventions, and copyrights protect specific creative or expressive works. And trademarks, which we haven't talked a lot about in these last 2 segments, they protect brand identities. And it's specific brand identities, just not a concept of a brand identity. Although ideas have value, they are not the substance of IP protection. While an idea is the starting point for any innovation or creation, without some tangible or intangible manifestation of the idea, intellectual property rights cannot attach to it. In patent terms, to be protectable, the invention must be conceived and reduced to practice. It sounds like big words, but let me tell you what that means. Conception is the formation in the mind of the inventor of a definite and complete idea of the operative invention, and the reduction to practice is the embodiment of the invention in some tangible form. For example, it could be reduced to practice in drawings, a written description, a patent application, or the making of a prototype. An example of an idea from a patent perspective would be someone saying, I'm going to create a vaccine to cure the coronavirus. That's it. No other statement, no other information, just this idea of creating a vaccine to cure the coronavirus. Without more, that's just an idea. So to have a conception of that idea, the conception of the idea would be the idea being complete enough that it could be explained to someone and teach them how to make and use your vaccine for the coronavirus. then the reduction to practice would be either writing down that formula, writing down or filing a patent application for it, creating a prototype of the vaccine. So an idea is just a starting point. There has to be more to this, just an idea. And we talked last week about copyright. When copyright protection attaches, that's when a work has been created and fixed in some form where it can be perceived or reproduced. So we have to get beyond mere ideas and into something more tangible. If ideas, just simple ideas, could be protected by intellectual property, just think about how less rich our world would be. For example, let's take a look at some of these ideas. On the copyright side of things, let's say Shakespeare was the first person to ever write down Romeo and Juliet. If that were the case, if we were protecting the idea in Romeo and Juliet of star-crossed lovers, the tragedy of star-crossed lovers, we wouldn't have things like West Side Story or the Hatfields and the McCoys, because those stories are also based on, the tragedy of star-crossed lovers. I gave you an example earlier of the coronavirus vaccine. If, let's say, Pfizer were the first to create a coronavirus vaccine, look how unfortunate we would be as to not have the Janssen vaccine or the Moderna vaccine or the others that have come behind it. So ideas, just protecting an idea really closes off innovation and creation. So we have to get beyond ideas. A more consumer product related invention, the Converse or Chuck Taylor shoe was the first basketball shoe ever created in the United States. If that were the case, that we could protect only ideas of a high top shoe that provided ankle control, we would never have the Nike shoe or the Adidas shoe or any other basketball shoe that come along. So again, and let's think about patterns, because I know a lot of you have questions about design patterns and whether they apply to three-dimensional objects or can it be patterns. So here I have example of patterns that could be protected by design patent. But let's say Chanel's interlocking C was the first idea of embodying a pattern on fabric that involved letters. That's the idea, embossed lettering on fabric. If we say that idea has been covered by Chanel, then we wouldn't get Louis Vuitton, we wouldn't have Gucci. So these are just some examples of how we have to go beyond the idea. We see that in each of these illustrations that I have here, the difference between Romeo and Juliet and West Side Story and the Hatfields and the McCoys is the expression of the story. Shakespeare told his story in one way. West Side Story put theirs on the east side of New York City. It was warring gangs and a lot of music and dance, a total different expression from Shakespeare. Well, Hatfields and McCoys put their folks out in Appalachia, and just again, a total different expression from West Side Story. Because we've moved beyond ideas, you can have different expressions of the same type of theme or idea. And the same with the vaccines. So I hope, for me, I'm glad that mere ideas cannot be protected, because it gives room for others to get involved in creation and invention. And we talked last time, for the first meeting, we talked about the big four buckets of IP protection in the United States: copyrights, trademarks, patents, and trade secrets. And I think, as the prior slide illustrated, these concepts refer to specific embodiments of an idea that has been created to the point where it can be explained to and understood by others. So copyrights, even though you have copyrights for creative works, it's a particular expression of that creative work. Trademarks, particular symbols, the brand, this Nike swoosh, the Adidas 3 stripes. Patents goes to particular machines, particular processes, particular compositions, and particular articles of manufacture, which we define as just things made by man. So it's just not the broad concept of these things, but it is the particular embodiment of, or how they are used or will be used in the marketplace. So what's not protected? We have these broad statements of what patents apply to and what copyrights apply to, but what's not protected? Particularly this falls under the idea of ideas, why ideas are not protected. So facts, anything related to facts. So some of you may have seen the play, the musical Hamilton. Well, Lin-Manuel Miranda has a right in the expression of Hamilton, the entire play, the music, etc. But what he could not prevent others from doing is taking the actual historical facts and using them, maybe perhaps in their own rendition of Hamilton, a Hamilton play, maybe writing a book about Hamilton. Those facts are compilations of facts, which just means it's a grouping of facts or a collection of facts, cannot be exclusively owned by anyone. Facts are things that are available to the public. And that's where we put ideas. Mere broad concepts of ideas on the copyright side of things belong to the public. On the patent side of things, abstract ideas, the same notion as an idea under copyright law, belong to the public. Mathematical algorithms, Pythagorean theorem, that belongs to the public. Nobody can exclusively possess the right to an algorithm. Blank forms don't qualify for protection under the Copyright Act. And information that's already in the public domain, like no one could run around and say, I own Shakespeare's Romeo and Juliet, because it's too old, it's already in the public domain. So there's certain things that are available that can't be protected under this broad umbrella of ideas. Facts would be considered historical ideas, which cannot be protected. So these are things that you would classify as available to all people are not protected by any intellectual property rights in the United States. So let's just take a look at what is protected under the United States Copyright and Patent Act, and even trademarks. So I'm giving the example of an iPhone because I'm sure all of you have some version of a smartphone. You either have the iPhone, which is one of the most popular, or the Samsung. So trademarks. We see here the brand. That's a brand symbol, iPhone. You also see the bitten apple. It's a specific symbol, specific word attached to a specific product. Trademarks are never used in a vacuum. They're always attached to a product. So you see the Apple here on this phone, but we know that Apple makes all kinds of things, watches, computers. They're now into rendering services. They have their iPods, they have their earbuds, all kinds of things. Trademarks must be used in conjunction with a specific product in order for trademark rights to attach. And we've seen two examples here. On the patent side of things, we can't really see the utility patents available to this iPhone, but if you turn it on and fire it up, you probably could, because it's the functionality, how the phone works. Those of you who've used an iPhone and maybe switched over to a Samsung, or used a Samsung and switched to an iPhone, you see that the operations are slightly different. That's because of the patent protection that's available to these phones. They have different algorithms that control how they interface with the internet, how they even send your calls, receive messages, etc. That's all part of the inner workings of the phone conducted by patent protection. These protections are specific. It's way beyond this scope of this course to talk about how patent protection is laid out, but I'll just simply say there's something called claims associated with the patent. Those claims have to set forth exactly what the invention is. Patent law gives some room for the inventor to try to claim a little broader than what they have actually invented, but the claims have to be specific so that one reading the patent will understand how to make and use the invention. They also have to be able to read the patent to understand what the scope of the invention is, just in case people want to design around the invention, as someone asked the question last week about designing around a patent claim so that you can create an improvement. Finally, copyright. On this iPhone, the software code, the instruction manual, and a lot of ringtones associated with the iPhone have copyright protection. If some of you can remember back to the early days of the iPhone, they had all sorts of ringtones, music you could download as a ringtone. But as folks became more and more savvy about copyrights associated with these smartphones, you see now both Samsung and Apple have a limited number of ringtones because they were infringing other folks' copyrights by allowing certain popular songs to be downloaded as ringtones. Trade secrets, well, we don't know what those are because they're secret. Remember, in a trade secret, you have to keep it secret. But I believe there's probably some trade secret information, probably in the way of algorithms associated with how this phone works. And then finally, I know we're going to get back to a topic that most of you, no, not yet, have asked questions about. Again, design patents. We just saw on the previous slide design patents attached to a fabric that has embossed upon it a certain pattern. Well, here, design patent attached to the look of this phone, the rounded corners, sort of the offset between the frame of the phone and the interior of the phone. The look of this phone had two purposes. It could serve as a design patent. It also could serve as trade dress. So sometimes there can be an overlap between design patent and trade dress. Unfortunately for Apple, the courts in later litigation with, I believe it might have been Samsung. Yes, it was Samsung. In later litigation with Samsung, Apple lost the trade dress protection for its iPhone. So we can have, you can start out with IP, go to litigation and can lose those IP rights. IP is not fixed just because you get it. Those rights are subject to challenge. Okay, so just a quick review to think about what you have. If you're talking about an innovation, a functional product improvement, you're thinking patent protection. You're thinking patent protection. Have you defined that innovation in a way that's clear enough and specific enough that you could explain it to someone and they would understand how to make and use the invention? If that's true, you've gone beyond an idea. And then you can create a prototype of that invention or write it or reduce it to practice in some form. Now you're well outside of idea. Design patents, usually you want to, it's related to how something looks. Sketch it out. Sketch out how that thing looks. Now you've gone beyond an idea. If for a design patent, I would say, let's say I wanted to create a novel looking drinking bottle, a takeaway bottle that I can take with me. If that's all I say, I only have an idea. But if I sketch out how that bottle looks in various orientations, now I've gone beyond a mere idea. And the same with trademarks, specific brand symbols, not just an idea of a brand symbol. Trade secrets, again, trade secrets protection would follow along with patent. The secret has to be specific enough that people would understand it. You want to keep it secret, so who would you be explaining it to? People within the company. And license agreements don't really apply here, but we talked about last week how they can be effective in helping protect your IP. So let's say you've done everything right. You've gone beyond mere ideas and you've tried to protect your IP. You've used contracts in the way that we talked about last week. What happens if you look out and you say, hey, that's my idea? You find that someone is infringing your intellectual property rights. The first thing you want to do is make sure you own the IP. We talked a little bit about this last time. Who owns it? When you commissioned your employees to invent, were the employees under some obligation to assign those inventions to you? You have employees creating certain documents in the scope of their employment. Under copyright law, yes, the employer would own those things. But let's say if you're working with a contractor and you hired a contractor to create some documents or to design some logos for you, Do you have in place agreements with those contractors where that work would be, the work product they create would be assigned to the company? If so, then you probably have a good case for ownership. If you determine that you have ownership, the next thing you want to do is decide, is it worth the cost for you to go out and enforce your IP rights? IP litigation, as we'll talk about in just a moment, can be very expensive. So you want to find out, what's the cost benefit analysis? Is what someone has taken from my company the core of my company or the soul of my business? If that's the case, and you would be out of business but for this IP, because somebody's infringing your IP and their infringement is going to impact whether you can sustain your business or not. If you have the resources, then I would say you need to go and think about ways to enforce your IP. If it's ancillary to your business, let's say you created a shipping method that gives you some advantage in the marketplace, but it's not bringing in the sole basis for sustaining your business. You have other proprietary rights that help continue your business, then you might not want to sue. And I say that, or you might want to pursue other options and avenues to enforce your IP rights other than litigation. You can always negotiate. I say anything is negotiable. But if you resort to litigation, I'm going to talk about expense first. I have just been in my clinic. Remember, we work with pro bono clients. These are clients who come to us. They're small and emerging businesses. We represent them for free. Most of them cannot afford legal services because we know the cost of legal services can be out of reach for small businesses. Well, this young man came to us. Someone had stolen his trademark. It was it was a family business that had been doing business under this trademark since the 1950s. Someone came along, started putting product in the marketplace that was subpar, and attached this young man's brand name to the products, and the products where he was getting all kinds of complaints about these products. Well, on a pro bono basis, we represented him for 7 years in this opposition, trademark opposition. It ended up rolling over to litigation. This young man, if we had been charging him to represent him in these opposition matters and the trademark litigation matters, he would have spent in excess of probably $7 million. But luckily for him, we had a group of students that could work on the case for free. But the cost of litigation can be astronomical. It's not unheard of. When I was in-house, I worked on a litigation that cost us $28 million to litigate it. Fortunately for us, we won it. And so we were able to recoup our fees and got some damages. But litigation can be a costly endeavor. So think about ways, is it the cost benefit? Is it worth it to go after the litigation? Can you compete in the marketplace despite somebody infringing your IP? Now, there are litigation funding sources. If you find yourself in a situation where you have some really valuable IP and you feel like after consulting with an attorney, you feel like you might have a good case to win it, there are these funding sources that will back your IP. They will back your IP litigation. They will back your IP litigation for a cut of whatever damages you get. I've never worked with any of these sources. They call me all the time, asking me if I have any clients that need any support bringing litigation actions. I usually don't because we're a clinic, but just know that these firms exist. Don't know what the parameters are for working with them, but they're out there. So let's just take one more comment before I open it up for questions. What do you need to prove if you decide you want to go to litigation? If you're bringing a patent claim, you claim that somebody's infringing something that you have a patent on, you're going to have to prove, we talked about before, those claims. The claims in a patent set out exactly what the invention is. You're going to have to show that someone has infringed each and every element that you've laid out in the claim, or if not, they haven't infringed it with what we call literal infringement. You can show that the equivalents of what you have in your claims have been included in the infringing product. So you have to go through this. It's a very exact analysis on the patent side of things. On the copyright side of things, what do you have to prove? Copying. Under copyright law, there's a concept called independent creation. If somebody can show that they were locked in a back room somewhere, never had exposure to the internet, no exposure to the article that you claimed has been infringed under copyright, and they independently created it, then they have a copyright in that. Because independent creation, unlike patents, on the patent side of things, a patent can only issue to only one patent per invention. So there can't be multiple people out there claiming rights to the same invention because the patent law says only one patent per invention. But on the copyright side of things, because we're working with original works, if I create my own version of David, and let's say Kristen creates her own version of the David, I'm sure I'm referring to the David in Italy where everybody, I love Michelangelo's David and Bernini's David, but I create my own version and Kristen creates her own version. We have copyright protection. Both of us have copyright protection in our versions of David. So copyright protection is different from patents because you can have multiple copyrights on the same expressive work because the expression is unique to the individual. As long as Kristen didn't copy mine or I didn't copy hers, we both have independent creation. So in copyright, to prove that someone is infringing your copyrightable materials, you have to show that those materials have been copied. And there are various tests to show that. So in the end, what we want you to think about is, have I gone beyond an idea and into something that is expressive and defined enough from a patent perspective that I can explain it to somebody and they would understand what I've created, exactly what I've created, and they would be able to go reproduce it. On the copyright side of things, have I created an original expression that doesn't include things that may include things like facts, includes things like facts and historical events, but do I have something else that I can layer on top of that? Is there some creative expression that originates from me that I can claim as my original work? If so, then I have gone beyond an idea to something that can be protected. With that, I think I'd like to open it up for questions because even with that those brief remarks, there's a lot there. So let's see what questions you guys have.
We have a pretty quiet group today, but fortunately, we have a lot of questions left over from previous sessions that I think are relatable to this one. And again, feel free if you have questions while we're talking, throw them in the chat now and we have time to answer them. So talking about copyrights, I have two questions from that first session. The first is specific to landscape design. Is landscape design copyright eligible?
You know, there have been some cases that said landscape design to be copyright protectable. I haven't seen many cases, but there was, I believe, 3 years ago, a case came down and the court said yes, because I guess it's an original work that's in a tangible medium. Yes, the greenery will grow out and the design might be distorted, but for that moment of time where it's fixed in that medium of expression where folks can discern what it is and perceive it, it's protectable.
That's good news. We also had a question. You covered it before, but I think it bears repeating. The question is, are there set standards for licensing out your copyright to entities or individuals? Like, are there certain check boxes you have to check in order for it to be valid for you to license it to somebody else?
It's a good question. It's a little broad, but what I'm going to say, the one thing that you have to be aware of when you're licensing out copyright, rights and copyright, or even trying to assign rights and copyrights, The law requires those to be written agreements. And the reason for that is back when copyright was new in this country, there was the chance that there would be a battle of he said, she said. The employer or the hiring party might say, I hired this person to create for me, and they orally conveyed to me all right, title, and interest in the work. And the party doing the work said, I never said that. And then so it became one of these equitable situations. And it turned out to be that artists, musicians, our creative types were deemed to need protecting in the United States. Because if you think back in this country with regard to music, back in the early part of the 20th century, folks' music was being taken away from them. Folks were writing books and books and books of music, and these record companies or publishing companies were claiming ownership without giving any rights to the work, the person who created the work. So the courts deemed that our creative types needed protection, and that's when they said any conveyance of copyright must be in writing. So that's the big thing you need to make sure when you're conveying copyrights or even receiving rights in a copyright. Make sure it's in writing.
Great. We have a question in the chat about software, which I know you get lots of questions about software in general. And this question is, what's the best way to protect computer software? Would it be patent or copyright?
Ooh, that sounds like a simple question, but it is indeed complex. So copyright protection does extend to computer software. So I would say, I believe in belt and suspenders. So why not go for copyright protection? Because copyright protection is available for source code. How that code was written, it's human creativity. The way I would write the code and express it may be different from how somebody else would write the code and express it. So there's expressive creativity in code, so copyright protection would apply. Now, the question with regard to whether patent protection would apply depends. Because remember, I showed you a slide that says patent protection goes for innovations, how something operates. Yes, processes and methods are also covered by patent protection, but there has become some debate in the industry as to whether software actually falls within the bounds of patent protection if it's just mere expression of functionality. Does it affect a machine or convert a process in some way? So you might have protection in software. I can't say that the courts are, right now the courts are denying protection for software all over the place, even up to the Supreme Court. So I would say if you have protection, if you think you have software that does something, for example, a recent case that was allowed software protection was this compact storage case where the computer efficiency was impacted because the software allowed certain data packs to be compressed. Therefore, the computer could take on more memory, it could operate faster, et cetera. So the software actually had an impact on how the machine operated. That was deemed protectable. State Street, these financial processing algorithms, they're being invalidated all over the place because they're just algorithms. So yeah, I'd say to really determine whether you need to go for copyright protection and patent protection, this is one of those cases where you need to consult counsel.
Okay, we have two questions. I'll ask one at a time to keep it easy for you. The first is, we have a lot of small businesses listening in, and a lot of advertising and all sorts of communication with your clients happens on social media now. So for artists who are posting on platforms like Instagram to drum up business for their work, how can they protect their work through when they're posting on social media?
I would say if you're posting on social media and you're posting some things that you feel like might be protectable under copyright expression, Is it written work or is it artistic work? Use a copyright notice. And there's an example of the copyright notice in the first presentation, but that's the little C in the circle followed by your name. If you use these copyright notices, even on trademarks, use the trademark notice. That would be the TM placed next to the logo, or the registered R if you have a registered trademark. But the purpose of these notice symbols is to put people on notice that someone's claiming either copyright protection or trademark protection in that work. So that's the best thing you can do to protect yourself on the internet. Of course, if somebody decides to go ahead and infringe, then you're stuck with you're faced with, do you enforce your rights?
And a similar question for someone who is a photographer said they were once told that once your photo is posted on the internet, anyone can use it. Is that true?
Well, it's not true that once you post it on the internet, anyone can use it unless you're going to give them a license, unless you've entered into one of these commons licenses where people can just use your stuff for free. Photographs, if you're a photographer, the minute you take that photograph and it's stored on the digital memory of your camera, your rights attached. You decide to upload that photograph to the internet, you still have copyrights in the photo. What I would say is use the copyright notice so folks know that you're on notice. They're on notice that that photo is being protected under copyright protection by the photographer. So just because something's on the internet doesn't mean it's free to use. I have to caution people with that all the time. You go on the internet and you see little photos of Mickey Mouse. Believe me, you bring down Mickey Mouse, put it on your product and sell it, Disney will be on you before you can collect your first penny.
Yeah, I think there's a common misconception that you have to do something before you can put that little C next to your work. Like you have to apply for something. That maybe we should talk a little bit about when you can and can't use those specific symbols in connection with your work.
Good. We talked about that. For those of you who weren't in the first class, we did talk a little bit about that. On copyright protection attaches automatically. So as soon as the work is fixed, you take the photo, it's fixed on the digital memory of your camera, copyright protection attaches. So when you upload that photo to whatever media you want to upload it to, or you print it out, make sure you attach the copyright notice, because copyright attaches immediately. You don't have to register. You don't have to do anything else other than it's yours. As soon as you fix it, I write the great novel of my life. As soon as I put pen to paper, that copyright attaches. So there's nothing to do. With regard to trademark symbols, you can always use for your brand, your logos, your brand symbols, you can always use the TM. The TM is a designation that says, I'm claiming trademark rights in this logo or this brand image or this slogan or this word. I'm claiming trademark rights. I don't have a registration, but I have common law rights. And that's what the TM designates. Once a trademark is registered, federally registered, you can use the circle R. The circle R puts folks on notice that now the registration has been elevated to the point of federal protection. And there are some damage awards and benefits that go along with federal protection. On the patent side of things, if you file your first patent application, be it a provisional patent application or a non-provisional patent application, you can put patent pending on your products or the thing that's covered by the patent application. You put patent pending. Once the patent issues, then you can use the term patented and the patent number. So there are times when you can just put people on notice. In the United States, that you can always put people on notice by using certain notice symbols, and you don't always have to have a registration before you can use a particular notice symbol.
That's great, thank you. More questions coming in the chat. We have, when it comes to putting something in a fixed medium, a tangible medium, how does that apply to open, editable, shared Google Docs? Does that count as fixed? And do folks who work on it at any point own rights to all of the iterations in the future? that this happens a lot in collaborative small business settings.
Small business, particularly, let's say you're working on an advertising campaign. So once you modify it, you're creating different versions of that copyrightable thing. So depending on who's working with it, ownership may change, and it depends. Remember, you can use contracts to your benefit. If the document that's being created is created by employees in the normal course of their business, under law, that work, whatever it is, the advertising campaign, the marketing materials, the brochures, the user's manual, whatever you're working on, that belongs to the company. But let's say it is, you hired an independent contractor to come in and help with some of the development. You want an agreement up front. Who owns what? You want to make sure that the hiring company gets an assignment of all right, title, and interest from the developing company. I mean, the company that's been hired. Now, let's say you're the independent contractor and you want to maintain some rights. That's a source of negotiation. What rights do you need and why do you need it? If I'm paying you to create something for me, I'm not going to let you take what you create for me and go down the road to my competitor and use the same thing for my competitor. So I might give you some rights to say, you can use bits and pieces in your portfolio to show the kind of work that you can do, but I'm probably not going to give you all right, title, and interest to go and use it for somebody else. And that's fair. In the United States, we have a system called equity. It's fair. I paid for it, I should own it. And you did the work. You got exactly what you contracted for from me. I paid you to create, and you created. So what you created should be mine. I contract for that. And I can give you some limited rights. A lot of times, photographers want the right to put photos in their portfolio. So we can give you a display right to put it in your portfolio, but I won't give you the right to go license that same photograph to other people to compete with me in my business.
We also have a question, an interesting question on whether there's any way to protect recipes for things. If you create a recipe, what kind of options do you have?
Just a straight recipe is challenging because just straight recipes are usually not protectable under copyright because they're deemed functional. But let's say you create a recipe and you have all these, you write some description about how to create the food product, and you have some critique or analysis of certain baking tools or ingredients or oven temperature, all this, anything that's explaining something about this, the result of the recipe and how it's prepared, that may be protectable under copyright protection. But just a bare recipe by itself, you're going to have trouble. Some people do take their recipes and try to get patent protection. I worked for a fast food company that shall not be named, but many of their food products are protected by patent. So it went beyond just a recipe. It went to how to make the device. I call it a device because really look at these things, you're like, oh my gosh, this is what we eat every day. So it's how to make that food product. And so it just went beyond the, you have peanut butter, first layer of bread, some peanut butter and some jelly, and then the next layer of bread, you crib it all around. And it went beyond just peanut butter and jelly in bread. It went to how you make that peanut butter and jelly sandwich.
You must have so many stories from your from all of your adventures in intellectual property. We have a really good question in the chat that a lot of people ask, and it's about the breadth of applicability for copyrights and trademarks outside of the country. So if you successfully register a copyright or a trademark at the federal level, how far does that extend? And if somebody infringes on those rights internationally, what options do you have? What recourse do you have?
Thank you, whoever put that question in the chat. It was something that I had on my list to talk about, but decided I wouldn't because I didn't know if the small businesses would be interested in foreign protection. So I will talk about it now. With regard to, well, let's just speak generally. Generally, IP protection is territorial, so it applies within a particular jurisdiction. So US IP extends to the boundaries of the United States and its territories. Um, any protections in the UK, now that they're not part of the European Union, would be limited to the UK. Now, so that's true for patent protection. You get a US patent, it's protectable. You can enforce it in the United States. Trademark protection, you get trademark protection registered at the federal level. That gives you protection throughout the whole of the United States and its territories. Now, copyright protection is a little different. Copyright protection, because the United States has entered into some treaties with foreign nations, we can get copyright protection outside the United States for material that has been registered with the US Copyright Office. So I forget the number. I think it's close to 200, or it might be over, the number of countries that have signed what we call the Berne Convention. And the Berne Convention says that a country has to provide protection, copyright protection, to foreign nationals to the same extent it would to its own citizens. So what that says is, if I create some work in the United States that's protectable by copyright, I registered it with the Copyright Office, and then lo and behold, I find out somebody in the UK is infringing, but I don't have copyright registered in the UK. I, as a citizen of the United States, can go into courts in the UK and say, listen, I'm bringing a claim under the Berne Convention. You're UK, you're a signatory to that convention. So therefore, you have to afford me the same kind of rights you would afford the citizens of the UK. So here, I'm here to enforce my copyright protection. So copyright protection is the one piece of IP that we can take outside the United States and can be assured that we will have some enforcement rights in foreign countries, the countries that are party to the Berne Convention. The patent and trademark, they don't really offer those protections. There's some limited protection under the Trademark Act if you can prove that you have a well-known trademark, famous Mickey Mouse. Disney doesn't have to have protection anywhere except for the United States because Mickey Mouse is world famous. They can take Mickey Mouse to any Berne Convention country and say, I don't have a copyright in this country, but here's Mickey Mouse, he's being infringed and as a trademark. And they would be able to prove that Mickey Mouse is a famous trademark.
Great. We had a couple of other questions that I'm glad we have time to get to now that came up during our first session, particularly about trademarks. So while we're on the topic, the first is, what about taglines like Nike's "Just Do It"? You know, if a business is coming up with a tagline for their business, can they pursue trademark protection for that?
Yeah, those, I call those slogans, and we did talk about them a little bit in the first session, touched on them briefly. So the question is always, when you're dealing with these taglines, should I think about copyright protection or should I think about trademark protection? When you're talking about short phrases like "just do it," 2 all beef patties, special sauce, lettuce, pickles on a sesame seed bun, those logos are trademark protected. It's very rare that the Copyright Office will protect short slogans like that. So if you come up with something like "just do it," I created something just for a class project. I created a slogan that says, "Run barefoot into life if you have to. Don't quit." If I were using that in conjunction with, let's say, running shoes, the Vibram 5-finger running shoes that simulates barefoot running, and I associate that with those shoes, I would have a trademark. Slogans are trademark protectable.
Great. And then this is a kind of broad question, but I think it speaks to the kinds of questions that usually come up when people are thinking about intellectual property, particularly for trademarks. Again, how far do they extend? The question is, so I couldn't paint my box truck UPS brown, but could I paint my car UPS brown? Can I use the NBC tones in a song if it's only one tiny little portion of a huge song? If I use open a thing of Reynolds wrap in a movie I'm shooting, do I have to get permission to do that? How far does it extend, and how diligent should a business be in checking if they're infringing on somebody else's rights?
Such a good question. Because I think I mentioned that there can be overlap in these types of protection. So just because they're not these silos, I mentioned that sometimes something that's protectable by design patent can also be protectable by trademark, or what we call trade dress. So let's take the question with regard to the NBC chime. The NBC chime is a trademark, but I would think that they might have copyright protection on that chime as well. So if one were to take the NBC chime and incorporate it into a piece of music, if there's copyright protection on that chime, now you've infringed NBC's chime. So how far does it extend? It depends upon what protection you're under, and do you even know what protections attach? Because something could be copyright protection, something could be trademark protection, it could be patent protection, it could be copyright protection, or all of these things rolled into one. To give you an example, Mickey Mouse, Steamboat Willie version of Mickey Mouse is going to expire as a copyright in a few years. I think it's 2024. That's Mickey Mouse Steamboat Willie as a copyright. If you put Steamboat Willie on a product and try to sell it, you're probably going to have trouble with Disney from a trademark perspective, because they're probably going to let the copyright go because they have trademark rights in Steamboat Willie. So you have to think about what rights might attach. So it's always risky when you go into the marketplace and you want to use somebody else's product, somebody else's IP as part of your own. As far as the painting your car UPS brown, if you're in the package delivery service and you paint your car UPS brown and your employees are running around in brown uniforms, you're going to have a problem with the UPS. Why? Because the rights under the trademark law says that UPS has the right to prevent others from using brown in the marketplace in a way that will make folks think that imposter is UPS. So if you're engaging in package delivery services and your folks are wearing brown uniforms and you got a brown car that's UPS brown, UPS is in the package delivery service. So who says UPS couldn't try to become more energy efficient and put their package deliverers in small vehicles? So you just have to be careful and think about, on the trademark side of things, am I using this image in a way that might mislead consumers into believing I'm associated with the original owner? On the copyright side of things, I mentioned what has to be proven for copyright is copying. So if you copy somebody else's work, wholesale or bits and pieces of it, that's copying. So now you're at risk for copyright infringement. On the patent side of things, if you take somebody else's invention and they have claimed in their claims A, B, and C, and you recreate A, B, and C and add D to it and say you've created an improvement, well, you still have A, B, and C from the original patent. So therefore, your invention is a recreation of the original with some improvements, but you're still recreating the original. So you now have patent infringement problems. So think about what you're using and whether you copied somebody else's work or you misleading somebody into believing that there's an association when there isn't.
That's great. Yeah. I think we have time for one more before we close out for the day. So this one is about state versus federal trademarks. And can you have a state and federal trademark for the same thing? And then if I'm only doing business in a couple states, does it make more sense for me to just get a state trademark in those states? Or does it make more sense to get a federal trademark to cover me across the whole country?
Okay, so very good question. Yes, you may have both federal and state protection. And at the very early stages, that used to happen. Folks would go out and get both state registrations and federal registrations. I encourage my clients to get both, particularly when it's a question of whether the client is going to be actually doing business in what we call commerce, regulated by commerce. So that's interstate commerce, commerce between states, commerce between a state and a foreign country, or commerce with between a state and U.S. territories or within Native American nations. If it's questionable that my client is going to be doing business in that type of commerce, I will say go for federal and go for state, because state only requires you to be doing business within that state to qualify for state protection. So there might be sometimes when you want to overlap. Like I said, I like belts and suspenders to make sure my clients are protected, because to get a state registration usually doesn't cost that much money. In most states, it's less than $100. Most of them is even less than $75. So state protection doesn't cost you a lot. On the federal side of things, to get protection, you're looking at something less than $500. So a lot of times, trademark protection is within the budget of a small company. Now let's take the other part of that question. If you're doing business, let's say in Rhode Island and Connecticut, do you need a federal registration? Or can you just get a registration in Rhode Island, and can you get a registration in Connecticut and say that you're done with it? That depends. First of all, do you think you might expand outside of Connecticut and Rhode Island? Might you do business in Massachusetts? Might you do business in New Hampshire? We're so close here. Might you do business over in New York? Because, they're Connecticut, New York, we're all close right here together. So if you think there's a possibility of expanding outside the small geographic region where you're doing business, think about a federal registration. It'll cost you probably less than $500, say less than $1,000 to get an application put on file, versus running the risk of getting protection in the Connecticut and Rhode Island, and then all of a sudden somebody in Massachusetts is using your same trademark and you want to expand into Massachusetts. You don't have rights in Massachusetts because you never registered your mark federally. So if you think there's a chance that you might expand your service area, think about the broader protection. Think about the state protection. Federal protection. Federal protection, once you get the federal registration, you have constructive notice of use nationwide. There's some exceptions, but if you get a federal registration, you're sitting in Rhode Island, but you haven't used your mark in Illinois, but you have federal protection, basically you have federal protection in Illinois because of your federal registration. That means you could go into Illinois whenever you decide to expand that far and say, hey, anybody infringing me in Illinois, you have to stop because I have rights that go back to the date of my registration. Now, there's some legal exceptions to that counsel can work through you with, but the basic rule is federal registration gives you protection nationwide. State protection will give you protection within a state. So it depends. Where do you envision yourself doing business? And if you feel like you're going to only be in Rhode Island, file for Rhode Island protection. If you feel like you might expand out beyond Rhode Island or beyond Connecticut and Rhode Island, maybe think about federal registration. That way you don't have to go to each of these states and pop down money for just a state registration.
Great. We're at the end of our hour, but I'm hoping we can just fit one we have just one last question in the chat I'd like to fit in quick. We touched on it in the first session, but we get it all the time. I'm sure you get it all the time. It's about transferring your rights to somebody. This question is about, can you take your rights and put them into a trust for somebody to protect them, for the next person in line? This is more about succession, I think, and passing it along to people in your family.
It's interesting. I just had this question with a client. Yes, you can do that. But that's beyond the scope of IP folks. So if you're going to do that, please go to a trust and estates attorney to help you with that, because all kinds of problems can be run into trying to convey intellectual property through a trust. So make sure that you work with the folks with the right set of expertise to help you with that conveyance.
Thank you so much. Not to take anybody else's time for longer, and particularly not to infringe on your time, Professor. We're going to close out for today. Tomorrow is our last session. It's going to be a great one. It's the Small Business Roundtable. We have Professor Darden joined by 2 other experienced and dynamic professionals that are going to be there to answer questions. We have a whole bunch of great questions lined up that you've been sending along the way. We're going to have a really good conversation, kind of back and forth, and people in different realms and areas of expertise and with their own stories about Disney and fast food companies to share. So please join us tomorrow for that. Again, that's at noon. The same way you got into this one is the way you get into that one. The recording of this session and the recording of that session will be sent to you after the next session tomorrow. You're going to get the slides from today by email as well. We're also going to send you out a whole big resource list so you can look at what resources are available to help you beyond just sitting and listening to us talk at you for 4 hours over 4 days. Please feel free to join us tomorrow. We'd love to have you live asking your questions and listening in. You guys have been great and super interactive in making this useful for everybody. So I thank you for that. Thank you again, Professor Darden, and I hope everybody has a wonderful afternoon. Take care.